the Biden administration had a constant anti-India narrative running. There are senators there, I don't want to name them, who constantly have this India is bad on human rights, India is this, India is corrupt, all the time trying to paint India in a bad light. They said it was filed as a name and shame designed to levy accusations without any prospect of any trial occurring. It was a political move.
DOJ reply filed before the concerned judge, where DOJ made a strongest argument that and raised the issue of jurisdiction, legal basis, and timing, sir. How do you see that, sir?
Yes, the most important thing I read is what it says in paragraph under heading A, subpara 6. It says 4. It says the indictment was unsealed in the final days of the prior administration, apparently as a name and shame, designed to levy accusations without any realistic prospect of a trial ever occurring. This is what I have always said, at least it was my view, that the timing of this was such. The Biden administration had a constant anti-India narrative running. There are senators there, I don't want to name them, who constantly have this India is bad on human rights, India is this, India is corrupt, all the time trying to paint India in a bad light. And they were trying to pressure India. And I don't think it's any secret the Biden administration was not in love with India. So,
if the DOJ now sees no merit in the case, why was it filed, sir?
That's why they are saying. They said it was filed as a name and shame designed to levy accusations without any prospect of any trial occurring. It was a political move.
Sir, the DOJ response is being called unusually direct, sir. Do you agree, sir?
It's blunt. See, because the judge, the Attorney General's office obviously has taken offense. See, American English, the way they address courts and the way they write, it's very different from even the British here in England, the kind of language we use. And India, of course, is even more differential. America is more direct, even the judgments are in more direct language. So you have to account for that. But even by the American standard, this is a pretty hard-hitting statement. And obviously, somebody took offense to the judge saying your reasons are very terse. So he's saying, yes, they should be terse and they're rightly terse, etc.
Sir, how important is the DOJ claim that the case involved no US companies, national security, or criminal organizations?
That's absolutely correct. I think where's the doubt about that?
Sir, what happened next? Yes.
Obviously, he says that they had lots of people who carefully analyzed the evidence. And after the first section, they say in a limited waiver of privilege, they will explain why the charges were dropped. And he says, because you're asking me, I am telling you. And he said there were large number of attorneys who worked on the case. He started, then this is very important, he said this white-collar case was indicted in late 2024 without first hearing from defense counsel. Now you must know, unlike India, in America, before filing a case, they talk to the defendant. Because many times, if they say, we have this case against you, even a defendant may say, okay, on charges A and B, I don't want to fight you. I don't want to fight you. I will plead guilty. And penalties are to be levied. Penalties are levied. You don't waste time at the court and make it so high profile. He has said this was started before that was done. And what he writes is very important. He says, before I began in the office of the Deputy Attorney General, I had never heard of any of the defendants in this case. Some of the defense counsel requested a meeting to discuss the case. I made the decision to dismiss after conducting numerous meetings with defense counsel and also separate meetings with only department after reviewing hundreds of pages of materials prepared by both the defense and the department counsel after conducting my own research and analysis. And then he says he puts them under the fraud charges, he puts them under foreign corrupt practices, and he gives his reasons why he says this was a case which was bound to fail. The fraud was over broadly put. The charges, the FCPA charges, And he goes on to say the FCPA charges have to be dismissed because they do not satisfy the memorandum that was issued by the Attorney General. It was called it's something called, they call it a Blanche Memorandum, whereas a department-wide policy targeting enforcement actions, etc. And they said even that was not satisfied. They should never have brought this case. And he
Okay.
says, we have no evidence, we'll never be able to prove it.
Yes, sir. Sir, my last question will be what can happen next, sir? Will the judge close the case soon, sir? We
I
can
think he
expect
will
this?
have to. After this, he may have to. I mean, I don't see why he will not close it.
Okay. Thank you so much for
They are
talking to
very
NI, sir.
clear. If he doesn't close, for them it has become, they are raising it to a larger issue.
Okay.
They end by saying it is the constitution vests the prosecutorial power in the executive, not the judiciary. They are telling the judge whether to prosecute or not is for us to decide, not for you.